No?
According to law, of the involvement of his political opponent in making sure that he is imprisoned in The Hague. Di ba? Kasi, number one, red notice ng Interpol, that was not
Yes. What do you have to say po? Since we know you have been observing since day 1, day 2, bago ho mag-present ang depensa bukas. Since day 1 and day 2, how was your observation po? Kasi natanong na namin si Atty. Degra at Atty. Sal, kayo, we never asked you pa about this.
Wala kang, as of now, prosecution pa lang nagpipresent.
Opo,
We cannot make any comments till we have heard the side of the defense.
Pero ano masasabi po ninyo with the initial...
Personally, I see it as a political matter. Walang parang baliwala ebidensya dito eh. Walang chat tricks eh.
Attorney, what made you say so? Can you give us further insights on saan po nanggagaling, where that point of view is stemming from?
Well, puro storya lahat na hindi natin alam anong oras, sino, kailan. No? Walang sufficient definiteness kung sino ang probably hindi natin alam ang procedure dito sa ICC. Iba ang sistema nila. But as lawyers, as Filipino lawyers, we expect something different. Bigyan nyo kami ng nakikita namin na masasagot namin ng tama.
Attorney Magsasalita, could you tell us more about yung sa meeting yung kagabi with Kaufman? I mean, how was it?
Ano lang yung socials lang yan.
Okay. Hindi po na pag-usapan yung strategy or how the defense would approach?
Alam mo, it's trabaho nila yan. We do not want to intervene with what they're going to do. Of course, kanila lahat yan. We're just here to observe. And we were hoping that we could get a glimpse of our beloved president. But unfortunately, hindi pwede. So that's where we are right now.
Pero Attorney Kaufman mentioned that every hearing daw, you see each other and then you brainstorm, you deliberate. Dahil parang kinukuha rin ata ni Attorney
Every
Kaufman.
hearing?
I mean, at the end of the hearing ata nito, sir, the confirmation hearing charges.
The first time we met with him was last night. And the other day when we had a short talk during the lunch break, we didn't talk anything about starting the hearing.
As you mentioned, kahit this is political, so kahit anong ebidensya. What do you mean by that? So, no matter...
Personal na ano ko yun.
Alright.
Personal observation ko yun. Bigyan nyo kami ng laman para makita namin ano itong pinagsasabi. Kasi, umpisa sa tatlong patay, 4, naging 47, naging 5,000, naging 17,000. Where are we?
Hindi accurate.
And they're saying it's a crime against humanity. Have you watched yung mga criminal cases ng araw during the times of war? Ano yung crime against humanity? Hundreds of thousands being killed. Here, we're doing something. It's a national policy. Anong pakialam ng ibang nations dito na itong gusto namin gawin para tumahimik naman yung bansa namin. Pagod na kami. Pagod na siya. He saw it as a last alternative. Baka ito ang pag-asa ng linisin natin ang sarili natin. And we were on the right track. Unfortunately, our president had only 2 to 3 years to govern. No? Nabutan tayo ng COVID. 2 taon ang nawala sa kanya. Pero sa 2 taon na yon, anong nakita ninyo? Wala? Sabitin nyo nga ako.
Marami, sir. Maraming nabago, sir.
Ano naramdaman nyo? Sino best friend ng presidente? Kayo, ang taong bayan. No? Wala siyang iniisip. Hanggang ikukulong na lang siya, kayo pa rin na nasa isip niya. Masasabi ko lang kasi ako huli kasama niya bago kami nagkahiwalay.
So, ES, would you say na walang katotohanan yung common plan, yung parang sinasabi po, in-establish po ng prosecution during the confirmation hearing?
Alam mo, ito nga, natutulog na lang kasi tulog na tulog. Nag-aabang na something substantial o matapos na ito. Wala kami nakikita as Filipino lawyers.
Sir, ano pong comment niyo dun sa photo gallery na high value target, kill list?
Yung photo gallery?
Yung pinakita ni PRRD na may mga mukha
na
Yung
high
drug
value,
list
oh,
also.
drug list, high value
Well,
target.
meron siyang national policy. Ito ang mga taong binigay sa akin na involved sa mga drug trafficking. Bigay ito ng mga polis ko, hindi sa akin to. Part of the system yan. Meron tayong war against criminality, war against that. So, buti nga sinasabi, ito yung mga taong may mga kasalanan. No?
Sir, any comment po sa paggamit po ng prosecution ng sariling words po ng former president about his policy?
Tinatapos ba nila yung words ng dating presidente? Patayin natin, pero tapos you go. Do not go beyond the law. Otherwise, you're worse than criminality. Basahin nyo lahat yung mga pinagsasabi. Alam nyo, napansin ko, tuwing lumalabas ang boses ng presidente, nabubuhayan ng Pilipino eh. Miski na boses dyan ng nakaraan.
Do you think, sir, that the parts of the speeches were taken out of context?
Obviously. Kasi they're not picky.
Sinusuppress nila yung ano nasa loob eh. At saka yung mga... Bakit yung nagsosona siya? Ito ang aking war against drugs. What was the most applauded part of the speech? His policies against criminality, against drugs. And yet, he's being crucified now.
Attorney Delbra,
how would you
ang sabi
respond
po
kung
ng
Malacanang,
prosecution.
and particular assertions of armed resistance demonstrate consistency incompatible with isolated acts. Regardless of whether the direct perpetrators were formally identified as police officers, the similar tactics used show planning and coordination involving law enforcement authorities and, at times, local officials. Killings were not carried out by rogue officials or by vigilantes operating separately from the authorities. The police involvement in the killings extended well beyond the cases officially acknowledged as death arising from by-bust operations. Furthermore, the government failure to arrest, let alone prosecute, a single police officer for their role in any of the war on drug killings that Duterte has encouraged, sent a clear message that the one responsible need not fear accountability and can act with impunity. There is no evidence that Mr. Duterte took any steps to prevent or punish the responsible for the murders. On the contrary, as his numerous public statements made clear, he discounted the legality of police actions, showing no inclination or intent to investigate alleged crimes. Mr. Duterte encouraged the police to carry out his anti-drug campaign and repeatedly stated he would protect them from prosecution. On 19 July 2016, at a fellowship dinner with his former law school classmates, Mr. Duterte said the police officer could carry out their war on drugs without worrying about being prosecuted. He stated, and I quote, "The president can grant pardon, conditional or absolute, or grant amnesty with the concurrence of Congress. I will use it, believe me," end of quote. During a press conference on 21st August 2016, he also explained that his promises to protect the police was one of the reasons why the war on drugs had become so bloody. And I quote, "Remember, I went in warning everyone. I said it could be bloody because I knew that the police would now be equipped with a certain mindset, that they would be protected by law if they go in and have this, violent confrontation. Because before, they were afraid of these human rights, and a lot of them lost their jobs because they couldn't even have a lawyer to defend themselves." End of quote. Mr. Duterte also warned human rights organizations not to file cases against police and army officers for extrajudicial killings, saying, and I quote, "I would like to say now they will never go to prison, not under my watch." End of quote. This morning, Your Honor, Mr. Jeremy referred to the killing of the mayor of Albuera, Rolando Espinosa, who was killed inside the Leyte prison. At the time, the National Bureau of Investigation determined that the killings were a rub-out of two unarmed prisoners inside their cell and filed murder charges. Mr. Duterte responding, saying that the officers would not be prosecuted with these words, and I will quote, "I will not allow this," meaning officers, "go to prison. I don't care if the NBA says it is murder. Anyway, the NBA and the Department of Justice are both under my authority. I will be the one to answer for it and go to prison." End of quote. On his third day in office as president, Mr. Duterte publicly told police officers that he would pardon them if they kill drug dealers and drug addicts, using these words, quote, "Do your duty, and if in the process you kill 1,000 persons because you are doing your duty, I will protect you." End of quote. Given the prevailing perception of police impunity and the absence of effective investigations or prosecutions, in many cases victims did not file a complaint nor try to initiate criminal proceedings. As one family member of a victim explained to us, and I quote, "We had no hope for an investigation of the police. One of us saw one of the police go inside with an aluminium briefcase. He took out a gun and some shabu sockets and placed them next to the body. I went back to where I was, and I was totally shocked. I couldn't even complain. If we go complain, what is our chance against the authorities?" End of quote. In other cases, victims tried to seek justice. They went to the police, to local officials, to government agencies. They filed reports, they asked for investigation, they begged for answers, but their pleas were ignored, their complaints were dismissed, their testimonies were doubted. In some cases, the very people they approached for help were the same ones involved in the violence. They were left with no path forward. No institution was willing to hear them. No authority was willing to protect them. No system was willing to acknowledge what was happening. The attack against the civilian population was carried out pursuant to a state policy to neutralize, through violent crimes, including murder, individuals perceived or alleged to be involved in drug-related and other crimes. The policy was originally developed by Mr. Duterte and his close associates in Davao City and implemented locally, and then expanding to the national level in 2016, once Mr. Duterte became President of the Republic of the Philippines. Victims support the primary prosecution pleading and submit that the evidence shows the existence of such a policy as reflected in the repeated patterns of conduct the mobilization of state resources, Mr. Duterte's public endorsement, and institutional tolerance. Mr. Duterte first ran for mayor of Davao in 1988 on a campaign to restore law and order in the city, the largest of the main southern island of Mindanao. At that time, Davao was known as the murder capital of the Philippines. Communist insurgents and government security forces gunned each other down and many civilians day and night on Davao streets and barrios. Mr. Duterte was Davao mayor for most of the years between 1988 and 2016. Local NGOs indicate that squad killings of alleged drug dealers, petty criminals, and street children in Davao City started sometimes in the mid-90s, during Mr. Duterte's second term. The group that claimed to be responsible for the killings was called Suluguan Sakatuan, or servants of the people, amongst other names. But soon the media, as you have also heard in these days, the media began referring to it as the Davao Death Squad. The Davao Death Squad killed hundreds. Mr. Duterte endorsed the killings as an effective way to combat crime, relishing his Duterte nickname and reputation. His active promotion of the killing of suspected drug offenders led to a sharp increase in such killings during his time as mayor. According to one estimate, amongst the other that you have been shown yesterday and today, at least 1,424 such killings took place in Davao between 1988 and 2015. As you heard yesterday during the presentation of Mr. Nichols, and today during the presentation of Ms. Croft, when confronted with a death toll during his presidential election campaign, Mr. Duterte responded, "They said I killed 700? They undercounted. It was 1,700. As you also heard, Your Honors, on numerous occasions as mayor, Mr. Duterte claimed personal responsibility for the policy of killing drug suspects. Even prior to announcing his candidacy for the May 2016 presidential election, Mr. Duterte was already very clear about his intention to eliminate crime by eliminating criminals, applying nationwide the abusive crime control tactics. As reported in the Sunstar Philippines on 24 May 2015, he declared, and I quote, "If by chance that God will place me there, watch out, because the 1,000, referring to the person killed in Davao, because the 1,000 will become 100,000. You will see the fish in Manila Bay getting fat. That is where I will dump you." End of quote. 3 months after that speech, he renewed his pledge, and I quote, "If I become president, you better hide. That 1,000 will reach 50,000. I would kill all of you who make the lives of Filipinos miserable." End of quote. Mr. Duterte's outspoken vote to embark on a nationwide killing campaign against drug dealers and drug users was the foundation of his presidential electoral platform. During a campaign rally on 15 March 2016, he stated, quote, "When I become president, I will order the police to find those people dealing or using drugs and kill them. The funeral parlors will be packed." Following his election as president, as also explained this morning by Mr. Jeremy, on 9 May 2016, Mr. Duterte continued to declare unequivocally that his anti-drug campaign was focused on killing drug dealers and users. Speaking in Davao on 4 June 2016, he stated, quote, "If you are still into drugs, I'm going to kill you. Don't take this as a joke. I'm not trying to make you laugh, son of bitches. I will really kill you." End of quote. The next month, Mr. Duterte referred to children killed in his drug war as, I quote, "collateral damage." Mr. Duterte and his associates disregarded the most basilar principle of law, human rights, and human dignity. In September 2016, after the then UN Secretary General Ban Ki-moon denounced the drug war killings, Mr. Duterte called him a fool, adding, quote, "I will continue the campaign against the criminals. I do not have any pity for them. I don't give a shit. I am the President of the Philippines, not the Republic of the international community." End of quote. In a Human Rights Watch report issued in March 2017, Mr. Duterte's first 6 months in office were labeled as a human rights calamity for the Philippines. Mr. Duterte repeated public statements encouraging the killing of alleged drug offenders were not rhetorical flourishes. They were operational directives. The repeated calls to kill alleged drug dealers and users is indicative of a government policy to direct an attack against a specific civilian population. Public statements encourage lethal force. Law enforcement operations were organized and resourced. The rhetoric of eradication was translated into practice. The scale, coordination, and continuity of operations, coupled with public encouragement of lethal enforcement, support the inference of policy. When violence is normalized, repeated, and institutionally defended, as in the present case, it reflects policy. Turning to the alleged liability of Mr. Duterte. The suspect is charged as indirect co-perpetrator under Article 25(3)(a) for committing the crimes jointly with others in furtherance of a common plan or agreement to neutralize through violent crimes including murder, individual perceived or alleged to be involved in drug-related and other crimes. In the alternative, he is also charged under Article 25(3)(b) for ordering or inducing the Davao Death Squad and later the national network to commit the crimes, and under Article 25(3)(c) for aiding, abetting, or otherwise assisting members of the Davao Death Squad and later the national network to commit the crimes. Victims submit that the evidence presented by the prosecution allows to conclude that there are substantial grounds to believe that Mr. Duterte is criminally responsible for the crimes charged. In particular, the evidence shows the existence of a common plan to kill individuals perceived by the authorities as implicated in drug-related crimes. The common plan originated in Davao in the late 80s when the suspect instructed members of the death squad, police officers and non-police hitmen, to conduct operations against the targeted individuals, provided funds and other resources to achieve the aim of the agreement. As already recalled, Mr. Duterte made unequivocal public statements encouraging police and civilians to kill alleged drug offenders. Such statements indicate an intent to use the country's law enforcement agencies to engage in murders. Mr. Duterte was proud of his achievements at the point that he put his method at the center of his presidential campaign. When elected president, he adopted the same method as in Davao nationwide and continued to state publicly and unequivocally that his anti-drug campaign would focus on killing drug dealers and users. Mr. Duterte relied on the support of the police, which he exercised effective control over, to execute the common plan. Their loyalty was reinforced through financial incentives, promotions, and the maintenance of a system of impunity. Mr. Duterte had full knowledge of the crimes. As the Chamber has already heard, on 15 March 2016 in Lingayen, he announced that if elected, he would order police to locate and kill individuals involved in drugs, warning that funeral parlors would be crowded. On 7 May 2016, the final day of the campaigning for the presidential elections, Mr. Duterte made it clear that his threats were to be taken literally, and I quote, "All of you who are into drugs, you sons of bitches, I will really kill you. I have no patience, I have no middle ground." End of quote. Madam President, Your Honors, the loss victims carry is not measured only in the death of a loved one. It is measured in the empty chair at the dinner table, the birthdays that will never be celebrated, the dreams that ended abruptly, and the futures that were taken from them. As one of the victims put it, and I quote, "My loved one was not perfect. None of us are. But he was a human being. He was someone's child, someone's parent, someone's partner. He deserved dignity, due process, and the chance to defend himself. Instead, his life ended without warning, without explanation, and without accountability. For many of us, the moment we learned of our loved one's death was the moment our own lives changed forever. We were left with questions that no one in authority would answer. We were left with fear that speaking out would put us in danger. And we were left with a painful knowledge that the institutions meant to protect us had failed us." End of quote. The trauma of these events did not end with the loss of life. It continues every day. Families were left to navigate grief while facing stigma and suspicion. Many were told implicitly or explicitly that their loved ones had deserved what happened to them. They were made to feel ashamed for seeking answers. Some were threatened when they tried to file complaints. Others were told not to bother because nothing would come of it. Children who witness violence now struggle with fear. Parents who lost their children live with enduring guilt and despair. Entire communities still carry the memory of nights filled of sirens, shouting, and uncertainty. Your Honors, the victim's suffering is never abstract nor remote. It remains real, immediate, and ongoing. Your Honors, trauma is not always visible. It resides in the silence of the ones who are afraid to speak. It lives in the hesitation of a child who no longer feels safe walking outside, and in the constant fear of families who still look over their shoulders, wondering whether they will be targeted next. For the victims, the confirmation of charges is not merely a legal step. It is a recognition that their loved ones mattered. It is an acknowledgement that what happened to them was wrong. It is a message that they have not been forgotten. These proceedings offer something they had been denied in years: hope. Hope that the truth will be established, that the one responsible will be held to account, that future generations will not endure the same suffering. Justice cannot restore their loved ones, but it can restore dignity. Justice can affirm humanity. Justice can help them begin to heal. Madam President, Your Honors, for the purpose of a confirmation of a charges hearing, the prosecution must demonstrate substantial grounds to believe that Mr. Duterte committed each of the crimes charged. Victims submit that the evidence presented by the prosecution meets this evidentiary standard. The confirmation of all charges is not only legally warranted, it is essential to the integrity of international criminal justice. The evidence before this chamber establishes reasonable ground to believe that crimes against humanity of murder and attempted murder were committed in the context of a widespread and systematic attack against the civilian population, and that Mr. Duterte bears individual and criminal responsibility under Article 25 of the Rome Statute. Your Honors, the victims have waited years for this moment. They have been silenced, stigmatized, and denied justice in their own country. Today, they stand before you with the hope that justice, long denied, may finally be within reach. This court is their last refuge, and today, on their behalf, we ask this chamber to affirm that their suffering matters, that their rights matter, and that the rule of law extends even to the most powerful by confirming all the charges against Mr. Duterte and committing him to trial. This concludes my part, Your Honors. With your leave, I will give the floor to my colleague, Mr. Andres, for concluding our presentation. Merci beaucoup.
Judge Mottoch, thank you very much. Maitre Andres, you have the floor.
Madam President, Your Honors, I am Gilbert Andres. My colleague, Ms. Masida, earlier submitted that Mr. Duterte's anti-drug campaign disproportionately affected the poor and marginalized. What were the conditions of the victims targeted by Mr. Duterte's anti-drug campaign? How poor and marginalized were his victims? The victims targeted by Mr. Duterte's anti-drug campaign were from low-income, high-density communities. In an urban setting, this meant that some victims live in an area of about 69,000 persons per square kilometer during the relevant period. A typical floor area of the house of a victim in these high-density communities was about 6 square meters. For some victims, their house was as small as the area of 2 tables in this courtroom. The victims' houses were typically made up of wood, used tarpaulin, plastic, light materials, and some broken hollow blocks. Any material that they could scavenge and utilize. As the victims lived in high-density communities, their neighbors knew them very well. The victims lived in close-knit communities. The victims' close-knit communities meant that they immediately knew if a person was an outsider to their community. And any traumatic event that happened to these victims in their close-knit communities was known and whispered throughout their community. As the victims were from low-income communities, to survive poverty, their houses were homes to multiple generations of their families to conserve their meager resources. For Filipinos, especially from low-income communities, their family is not just the nuclear family. it is not just the husband, the wife, the children. Their family extends to the grandparents, the lolo and lola, and the siblings of a spouse, the brothers and sisters. The breadwinner of the victim's family was usually the husband, the father of the children. The victims either worked as daily minimum wage earners or as wage earners below the prescribed daily minimum wage, or as part of the informal economy, such as a vendor. The victims worked if there was work available to earn for their family's survival. But most of the victims would not have completed their education, nor have the proper training to secure stable jobs as part of the formal economy. If they were fortunate to be employed as minimum daily wage earners, in the urban setting, this amounted to about 500 Philippine pesos per day, or approximately about 8 euros per day during the relevant period. But for most victims, the minimum wage was really the maximum that they can hope for. The victims only hoped to earn at most about 8 euros per day. And for a family composed of the husband, the wife, and about 2 until 4 children, 8 euros per day is meager. There was also a cultural expectation for the breadwinners to help their elderly parents. The other spouse sometimes augmented this meager income by being a vendor or by taking temporary jobs. And if both parents were outside of their home, it was the extended family that took care of the children. Your Honors, the specific data may vary from victim to victim, but the victims hope that this data give the chamber a picture of their conditions under Mr. Duterte's anti-drug campaign. The already marginalized and vulnerable conditions of the victims exponentially multiplied the harm that they suffered, and they continue to suffer, which leads to our next submission. What were the grave effects and suffered harm of the victims, their families, and their communities resulting from the crimes charged against Mr. Duterte? Mr. Duterte's drug war campaign targeted the very humanity of the victims, of their families, and of their communities. In Filipino, the indirect victims expressed this in one sentence: "Inalisan kami ng dangal. We were stripped of our dignity." How so? First, Mr. Duterte publicly dehumanized the victims of his anti-drug campaign. This dehumanization of the victims was used to justify their eventual murders. On July 25, 2016, during his first State of the Nation address before the Philippine Congress, Mr. Duterte declared that, and I quote, "But human rights cannot be used as a shield or an excuse to destroy the country, your country, and my country." End of quote. What was chilling was that this portion of Mr. Duterte's speech garnered the most applause from members of the Philippine Congress and the public gallery. On August 17, 2016, during the 115th Police Service Anniversary at the Philippine National Police Headquarters, Mr. Duterte declared to the Philippine National Police that for those allegedly affected by drugs, and I quote, "And it has not only affected millions, but a lot of them are no longer viable as human beings in this planet." End of quote. On August 26, 2016, Mr. Duterte declared to a group of Filipino soldiers he visited in an army camp that, and I quote, "crimes against humanity? In the first place, I'd like to be frank with you. Are they humans? What is your definition of a human being?" End of quote. These public speeches of Mr. Duterte serve to condition the Filipino people on the excuse for the murder of the victims of his anti-drug campaign and how the murders were taken out, brazen, execution style. These public speeches of Mr. Duterte were emblematic of findings that atrocity crimes were often preceded by the process of dehumanizing the identities of others to justify the crimes. Second, the murdered victims were dehumanized by how they were murdered. During their actual murders, the targeted victims were summarily accused as drug users or pushers without the benefit of a judicial process, just like the one before this chamber. The victims were then murdered inside their homes or within their own close-knit community. The victims who were murdered inside their homes were murdered in front of their family, their spouse, their children, or their parent, especially in front of their mothers. Some of the victims were forcefully separated from the physical clutches of their family members, protecting them from the direct perpetrators of Mr. Duterte's anti-drug campaign. This was what happened to the son of a victim in the early hours of a Thursday. At that time, this victim, her son, and her son's wife, who was pregnant and nearing delivery, were preparing to go to the hospital when 6 or 7 people dressed in black and who had guns suddenly entered their house. As recounted by this victim, and I quote, "My son kept repeating, 'Mama, don't leave me.' So I blocked the way. He pleaded again, saying, 'I will come with you, just don't kill me. Mama, don't leave me.' 4 officers were inside. One shouted at me, 'Get out of the way!' They pulled me down the stairs and yanked my hair. They had guns. My son pleaded again, 'Mama, don't leave me.' He was hugging, referring to his wife. They dragged me out into the street and put me on a motorcycle. Some victims begged the direct perpetrators for their lives, as witnessed by their family members. Some victims spontaneously took off their clothes to show to the direct perpetrators that they were clean. The home, which was supposed to be a shelter of security for the direct victims, became the crime scenes of their brazen murder. The targeting of the victims in their own homes is explained by the Philippine National Police Command Memorandum Circular number 16-2016, which was earlier referred to also by the prosecution. It was issued on July 1, 2016, by the then Chief of the Philippine National Police, Ronald Bato de la Rosa, appointed by Mr. Duterte. The relevant portion of CMC 16-2016 states that, and I quote, "The actual house-to-house visitations of suspected drug personalities shall be the highlight of Project Tonghang." End of quote. Project Tonghang refers to Mr. Duterte's anti-drug campaign on barangay clearance operations. Ultimately, The murdered victims were now known in their close-knit communities with the stigmatized label of natokhang and as drug users, despite the lack of any judicial declaration. Third, the murdered victims of Mr. Duterte's anti-drug campaign were further dehumanized even after their death by the false narrative of nanlaban. After the actual murder, the murdered victims were falsely portrayed as nanlaban, that they allegedly fought back against the police despite being the helpless victims. After the murder, evidence of illegal drugs and/or paltik guns were even planted on the murdered victims as part of the modus operandi of the anti-drug campaign to allegedly show that the victims purportedly fought back. Thus, the murdered victims were not only known as natokhang and as drug users, they were also now known in their close-knit communities with the false label of nanlaban, or someone who fought back. But for the surviving family members of the murdered victims, the suffered harms do not end there. The extreme trauma brought by the sudden murder of the Tokhang victims was further carried over to their surviving family members. Some of the surviving family members were even imprisoned and charged with fabricated criminal complaints while they were still grappling with the trauma of the sudden attack and the murder of their loved ones. For the victim I earlier referred to, after her son was forcefully separated from them, she and her son's pregnant wife were both arrested and detained in a police precinct. While under detention, she was told to get her son from the morgue. But they were not actually released from detention. They were actually photographed with the foils and rocks handed to them, and afterwards they were charged with fabricated complaints relating to illegal drugs, as that victim narrates. And I quote, "While in detention, I learned that the same thing had happened to all the other detainees. Their stories were the same. It took more than a year before this victim was released from imprisonment. The illegal imprisonment of surviving family members was part of the modus operandi to prevent the indirect victims from filing criminal complaints against the direct perpetrators of Mr. Duterte's anti-drug campaign. Thus, the document containing the charges in paragraph 19 refers to, and I quote, other violent crimes under Article 7.1, end of quote. Further, as the homes of the murdered Tokhang victims were the homes of multiple generations, how the murdered victims were brutally shot at have been traumatically witnessed by their family members, by their spouse, their children, or by their parents. This extreme trauma is a daily struggle for the surviving family members as they still live every day in the scene of the crime, their homes. This extreme trauma of the surviving family members also occurs when they see or about to encounter a police officer, or worse, the direct perpetrator in their community. But the extreme trauma of the surviving victims does not end there. The surviving victims were socially stigmatized in their close-knit communities with the label, natukhang sila, or may natukhang sa kanila, which loosely translated means they have a family member killed in a tokhang operation. The surviving family members of the murdered victims were avoided and shunned in their close-knit community. The neighbors avoid the surviving family members, fearing for their own lives by reason of association with the murdered tokhang victim. And the surviving family members usually mourn alone during the wake of their murdered loved ones. For some surviving family members who cannot endure this social isolation and continuing stigma, they eventually leave their close-knit community. The trauma and stigma are especially worse for the children of the murdered tokhang victims. Aside from losing a parent, usually their father, who is the breadwinner, the children, as direct descendants of the murdered victims, were avoided at school or even bullied as the children of natokhang. The children of the murdered tokhang victims have to endure bullying, stigma, trauma, depression, and some even develop symptoms such as epilepsy. And because the murdered tokhang victims were usually the breadwinners of their families, their death meant that their surviving family members were pushed toward further poverty. The surviving family members experienced extreme socio-economic dislocation with the murder of their breadwinner. Thus, Mr. Duterte's anti-drug campaign, aside from murdering victims from low-income communities, also brought about the breakdown of the families of the murdered victims. Mr. Duterte's anti-drug campaign destroyed the trust in the close-knit communities of the murdered tokhang victims and ultimately destroyed the social fabric of these communities. Ultimately, Mr. Duterte's anti-drug campaign not only murdered people, but perpetrated state terror against low-income, marginalized communities across the Philippines. As a result, Mr. Duterte's anti-drug campaign shattered and terrorized these close-knit communities as a means of control. And ultimately, as the targeted victims of Mr. Duterte's drug war campaign were from marginalized, vulnerable communities, his drug war campaign was not really a war on drugs. It was a war against the poor. And the continued stigmatization of the indirect victims, the surviving family members, still persists until now. The children of the murdered victims are still suffering psychologically, mentally, and socio-economically. Their widowed mothers and their extended families, the grandparents, usually the grandmother, or aunts or uncles, also bear the burden of providing for the children of the murdered victims. And some surviving family members are still being visited or watched by the direct perpetrators to check on them. Last, what do these proceedings mean to the victims? The proceedings before this chamber are being watched intently by the victims because they see it as their first step towards the truth and towards justice. There is still a culture of denial that subsists even in the close-knit communities where the victims reside. The family members of the murdered victims still cannot openly discuss the murder of their loved ones in their close-knit communities. And some quarters supportive of Mr. Duterte even publicly claim that these murders under the drug war campaign allegedly never happened or were merely fake news or were justified as necessary. These hearings on the confirmation of charges are vital to the victims of Mr. Duterte's anti-drug campaign because it will be the first step for them in actualizing their right to the truth and to justice under international law. Madam President, Your Honors, the victims know that their murdered loved ones suffered under the charge of crimes against humanity for murder being charged against Mr. Duterte. Your Honors, the victims know, they have seen with their eyes, they have heard with their ears, and they have witnessed the barbarity of the murder wherein their loved ones' human dignity was never respected. Thus, the victims pray that this chamber confirm the charges for crimes against humanity for murder against Mr. Duterte for the sake of the truth and for the sake of justice for the victims. And so that the murderous legacy of Mr. Duterte's anti-drug campaign will not find new victims in the future. Madam President, Your Honors, thank you for your time and kind attention. This ends the submission of the Common Legal Representative for Victims. May it please the Chamber.
Judge Motok.
Merci beaucoup.
Thank you very much. Mr. Andres, I gather that you have finished. So this second day of our hearings has come to an end. In accordance with our schedule, the hearing is suspended until Thursday, 26 February at 10 in the morning. Thank you, parties, participants, our interpreters, the registry, technical staff, and all those who have worked on this hearing and allowed it to be held. I wish you a pleasant day, and we will see you on Thursday. The hearing is adjourned.
All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Bonjour à tous. Je souhaite la bienvenue encore une fois à tout le monde à l'intérieur, à l'extérieur de cette salle d'audience. Madame la greffière d'audience, veuillez annoncer l'affaire, s'il vous plaît.
Good morning, Madam President, Your Honors. Situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte. case reference ICC 0121-0125. And for the record, we are in open session.
Merci beaucoup. Je demande maintenant aux parties et aux participants de confirmer que les personnes présentes dans la salle d'audience sont les mêmes que les audiences d'hier. Monsieur le procureur adjoint.
Bonjour, Madame la Présidente, Mesdames les juges. Il y a quelques changements dans la composition de l'équipe du bureau du procureur. Je représente bien entendu moi-même le bureau comme hier. Et à mes côtés, il y a le premier substitut, Julian Nichols, qui était aussi là hier. Donc, et devant, M. Edouard Jérémy, qui est substitut. Madame Robin Croft, substitut. Gio Jeong, derrière, associate trial lawyer. Madame Sylvie Wacom, également associate trial lawyer. Antonella Giordano, lawyer, Romina Bekiri, lawyer, et enfin, M. James Miriti, notre case manager. Je vous remercie.
Merci beaucoup, monsieur le procureur adjoint. Les représentants légaux des victimes.
Bonjour Madame la Présidente. Seulement un changement pour nous aujourd'hui. Nous avons défection à la dernière ligne. Il y a Miss Gaia Conti qui ne pourra pas être avec nous aujourd'hui. Merci.
Merci beaucoup, Maître Matsida. Merci. Enfin, la dépense, Maître Kaufmann.
Good morning, Madam President. Good morning, Your Honours. We are exactly the same composition today, and we are once again ably assisted and supported by our Filipino colleagues in the gallery.
All rise, veuillez vous lever. The International Criminal Court is now in session. L'audience de la Cour pénale internationale est ouverte. Please be seated. Veuillez vous asseoir.
Bonjour à tous.
Good morning, everyone. I'd like to welcome everyone in the courtroom, as well as those who are listening in from outside the courtroom. Court officer, please call the case.
Your Honors, situation in the Republic of the Philippines in the case of the prosecutor versus Rodrigo Roa Duterte, case reference ICC 0121-0125, and for the record, we are in open session.
Merci beaucoup.
Thank you very much. I would like to ask parties and participants to confirm that those present in the courtroom today are the same as the people in attendance on Tuesday. Mr. Prosecutor, the prosecutor. Good morning. The OTP is represented by the team. Mr. Ido Duke, associate trial lawyer, is one additional. I myself, I am back after a short absence. The presiding judge, thank you very much. Legal representatives of victims, Ms. Masida. Ms. Masida, thank you. Good morning, Your Honor. It is the same team as Monday, not Tuesday, but Monday. The presiding judge, thank you very much. We can now turn to the defense. Mr. Kaufman. Good morning, Madam President, Your Honors. It is the same lineup as previous days. I will go no further than that in French. The presiding judge, thank you very much. We can now move on to the defense and their submissions on the merits. Mr. Kaufman, you may address the court.
Now, before I start, I would like to make one general comment, and it's a comment which every defense counsel who appears before this court is obliged to make. So if the mainstream media in the Philippines and the NGOs reporting on his case today report anything about the defense's submissions, I hope that they will at least communicate the following faithfully. The defense does not disrespect the soul of any deceased person, nor does it make light of the loss of life. Any criticism made by us today will not be leveled at the loved ones of those such as the tearful relative who I saw in the gallery here on Tuesday. The defense's criticism will be confined only to the prosecution's document containing the charges, which governs these proceedings, not what has been reported elsewhere in the media. It's not the defense's role to give an alternative narrative, nor to give an explanation for the facts and figures presented by the prosecution. The defense's role is simply to persuade Your Honours that Mr. Rodrigo Duterte should not remain in detention for years to come, simply because the prosecution cannot make out substantial grounds to believe that this individual committed the crimes with which he is charged. Now, Mr. Julian Nichols confidently said the other day that you can ignore Rodrigo Duterte's speeches. Disregard every speech ever made by Mr. Duterte, he said. Throw them all out. There is still ample evidence of the substantial grounds based on the other evidence. That's transcript T4, page 45, lines 5 to 6. Helpful advice from no less than the day-to-day prosecutor in charge of this case, because we will show that the evidence is not substantial, rather totally inadequate. But in any event, since I can leave no stone unturned, I now turn to those speeches. Now, if there's one thing that I've learned from the domestic media coverage of this case, it is that journalists and their editors have a tendency to fixate on the salacious elements of a person's speeches while ignoring the less interesting parts. And so it was with Rodrigo Duterte. the prosecution has had its opportunity to show you a selection of these speeches and seems to believe that the more they show, the greater the chances of convincing Your Honours to confirm the charges. But what the prosecution has not told the public is that in its document containing the charges, which governs these proceedings and nothing else, it has only supplied 20 of these speeches as proof of criminal intent. And as I mentioned in my opening statement, 10 of these speeches, including 2 referred to by the Deputy Prosecutor, actually contain an exhortation to the use of lawful self-defense. Thereafter, we found a further 35 speeches, which will be found at tab 9, 11 to 26, 29 to 35, 37 to 41, 43 to 46, 137, and 152. Now, this is obviously not a competition. The point we really merely wish to make is that relying on the former prosecutor's speeches as a means of proving criminal intent is impossible. Now, I'd like to go back to that one speech which I promised the other day to show you. This is a speech, the second speech that the Deputy Prosecutor referred to in his opening statement. And this refers to the responsibility that Mr. Duterte said that he would shoulder, promising to shield rogue officers from prosecution. If we may, the first of these speeches, and I quote what the Deputy Prosecutor read from this speech. So the police is under the DILG, so I have to believe the story of the police, for simply they are my subordinates and I am ultimately responsible for their deeds. Now let's look at what the Deputy Prosecutor didn't state from the same speech. And the order is simply this: go out, arrest them if you can, but if there is no peaceful method of doing it and you are presented with violent resistance, thereby placing your jeopardy in your life, you shoot, well, the son of the bitch. Mr. Duterte's language, obviously, but nevertheless an exhortation to lawful self-defense. Let's have a look at another one of the prosecution's speeches mentioned in their pre-confirmation brief. Once again, on shielding criminal agents from prosecution. I quote, this is, I apologize, PHL OTP 00001127 at page 5. And I quote, but if you do your duty, do not worry about cases. I'll protect you. Believe me. That's why I will protect them. And if there's somebody who will go to jail, it's me. I will assume full legal responsibility. Now let's have a look at the exonerating element, which comes right underneath the allegedly incriminating element. He said, just do it right. We have our trainings that you can only kill if your life is in danger, and you are there performing the duty of a law enforcer. That's about it. Now I will turn to one of our speeches that we found in our research, one of the 35 that the prosecution didn't find. And I will terminate there because we have the rest, which we've referred you to in the tabs. So this is an exonerating speech which the prosecution either missed or ignored because it doesn't suit its case. And it was a speech which was made right at the start of the presidency, which could be seen as setting out the standard for his presidency. Mr. Duterte said this: I promised them I will suppress crime and take control of the drug situation, which was really running wild in our country today. Make no mistake about it. I repeat, again for all and for everybody's consumption, do not kill if you are not in danger of losing your life. Well, it goes on. You can see it there on the screen. Well, of course, the prosecution knows that we are going to argue that many of these speeches, in fact the majority of these speeches I would say, contain this exhortation to the lawful use of self-defense. And the learned counsel, Mr. Edward Jeremy, for the prosecution, tried to get around the problem by inventing the novel concept of the elastic mouth, which out of one side emanates the nasty truth, while out of the other side issues the supposedly disingenuous advice for the police to act in self-defense. But I ask Your Honours and the people of the Philippines listening in today, how many times did you hear the former president state at the beginning of any address that he had the speech of 2 pages prepared, but to his regret, it didn't come from the heart? And then he would proceed to speak at length, sometimes for an hour or more, in his own uniquely colourful and crusty language, exposing his homespun theories on crime control, swearing a bit here, boasting a bit there, and generally delivering a speech more akin to Finnegan's Wake than a Gettysburg Address. That does not suggest crafty design, hinted at by Mr. Jeremy, quite the opposite. Mr. Jeremy's resort to the say one thing, mean another thing theory is complete supposition. It is not a legitimate argument, because it implies that one cannot rely on anything coming out of Mr. Duterte's mouth, and that does not help the case for the prosecution at all. Well, that's about it for the speeches. I'll now turn to crimes against humanity and the contextual elements. And here I would like to start off by addressing the requirement that the acts of murder alleged be committed as part of or in themselves constitute a widespread or systematic attack. The second requirement is that these acts of murder be directed against the civilian population. With respect to the unique ICC requirement of an organizational policy, I would suggest that this concept has been conflated with the common plan, and as such, I shall address the matter later in my submissions. So, to start by reference to the widespread or systematic nature of the attack, I would like to draw Your Honour's attention to the fact that Count 1 contains 9 incidents of murder in one city, Davao, hardly widespread. Ms. Robin Croft, in her submissions yesterday for the prosecution, Tuesday, told you that the widespread nature of Count 1 was evidenced by the multitude of bodies in a quarry, a mass grave. Well, the prosecution and the authorities in the Philippines have had years to continue its investigations since the judicial warrant was reimposed. I mean, they could have dug up the entire city of Davao, but all they have managed to produce, the prosecution on the matter, is a reference to Leila de Lima in a Senate committee where she talks about the discovery of a few human remains which could have belonged to World War II Japanese soldiers. The same goes for another witness's outlandish assertion that bodies were thrown into the sea off the coast of Davao. Well, the whole Gulf could have been dredged, but not one executed corpse has surfaced. As for counts 2 and 3, Ms. Croft showed us some maps with coloured dots to indicate the magnitude and geographical spread of what the prosecution alleges, without, of course, proving that they were extrajudicial killings not countenanced within the 49 incidents. Indeed, for this reason, there is nothing to link the charged incidents, those 49 incidents, to the wider picture. According to the appeals chamber, which confirmed a pre-trial chamber ruling on the matter in Bagbo, filing number 432 in the case record at paragraphs 35 to 36, any factual allegations outside the charged incidents, in this case masses of generically alleged extrajudicial killings, must be proved to the required standard. And for this, NGO reports, academic statistics, and media articles are, as a rule, considered insufficient. Ms. Croft also screened images taken from the Duterte administration's PDEA report for the years 2016 to 2019, if we can pull that up now, which cite figures of the number of deaths of drug personalities in anti-drug operations without proving that they were illegally murdered, but she neglected to contextualize these numbers by reference to other parts of the same report which show that in comparison to the number of arrests and operations conducted, the number of deaths are minimal. Please, if you will, show a bar chart that we have helpfully prepared with the figures and a pie chart with the percentages. So, if I may just conclude, the only thing that is widespread here, or rather spread wide, is the utility of the prosecution's statistics. Now, turning to the civilian population, or the target of the attack, let me say straight away that the prosecution case theory, with respect to the definition of the targeted population, is, to put it extremely politely, muddled. In layman's terms, the prosecution has hedged its bets by presenting two alternative propositions, hoping that this pre-trial chamber will settle for one of them. From paragraph 17 to paragraph 20, inclusive of its document containing the charges, the prosecution argues that Mr. Duterte launched an attack on the entire population of the Philippines, pursuant to a policy to neutralize persons perceived or alleged to be engaged in crime. In paragraph 21, however, this so-called attack is directed not against the civilian population at large, the whole population, but rather against a considerably smaller and nebulous margin of society, namely the alleged criminals themselves. Let us start by dealing with the first scenario, namely that the former president, whose loyalty and love for his country is and has always been beyond question, launched a wholesale attack on the whole population of the Philippines, on the entirety of his nation, including the very same people who put him into power. Such a suggestion is not just incomprehensible, it is quite bizarre. The reason for this rather strange assertion, so I submit, is grounded in the prosecution's latest brainstorm on the matter, which it set out last year in a brief appealing a decision of this very same pre-trial chamber in the El Hishri case. And I do apologize in advance for the rather dull expose which will follow, but I do find it instructive to illustrate the chameleon-like nature of the prosecution's case theory. In this instance, Your Honours found that the civilian population attacked by El Hishri comprised prison detainees professing a certain political ideology. In so doing, Your Honours declined to issue an arrest warrant for El Hishri, where the victims of his crimes had been detained for totally unconnected and non-political reasons. Now, you might ask yourselves, why did the prosecution decide to appeal this decision? It was not as if it had been denied the arrest warrant for El Hishri that it had sought. Well, a key to the answer, so I believe, is to be found in the chronology of the events. On 10th February 2025, the prosecution rushed out its application for Mr. Duterte's arrest, believing that a unique opportunity to apprehend him had arisen. In this application, the prosecution defined the attack perpetrated by Mr. Rodrigo Duterte as being aimed at the entire population of the Philippines. Let us now fast forward to 10th July 2025. the pre-trial chamber, this same pre-trial chamber, ordered the arrest of Khalid al-Hishri for an attack on an objectively identifiable civilian population of detainees, while finding no justification to suspect him of crimes committed against a discrete subsector of that population, exhibiting characteristics distinct from those of the general population. Well, as you can guess, the prosecution didn't like that decision and hastened to appeal it. Not, I would suggest, out of any true concern for the purity of international humanitarian law, but rather because it put a spanner into the works of the Duterte case. That is, the only other active case that it is prosecuting before this court. After all, if we apply the resulting logic of Your Honour's decision in al-Hishri to the prosecution's case theory in the Duterte case, at least as it stood as of 10 July 2025, then alleged drug pushers and alleged criminals would be deemed a separate, subjectively defined subgroup of the general Filipino civilian population, displaying different characteristics and, as a result, excluded as targets of the attack. So, 8 days passed between this decision of yours, Your Honours, and the notification of the confidential version of the prosecution's pre-confirmation brief on 18 July last year. And I'm prepared to wager that while beavering away with their attempt to appeal the al-Hishri decision, the gurus on the top floor of the Office of the Prosecutor were also frantically discussing how to deal with this inconvenient fly in their conceptual ointment. They had to think of a way to accommodate this pre-trial chamber's ruling while not compromising their appeal. So, lo and behold, and rather unsurprisingly, the pre-confirmation brief contained a new feature, namely the second scenario to which I referred earlier, that the target of the attack was not the Filipino as a whole, but the suspected drug pushers and criminals. Now, even if the former president did promulgate an organizational policy of eliminating suspected criminals and drug pushers, which he most definitely did not, this policy did not and could not constitute an attack directed against a clearly definable civilian population. Firstly, the segment of society victimized cannot be said to display objective characteristics distinguishing them from other members of society and thus rendering them susceptible to an attack. After all, how does one define a suspected drug pusher or suspected criminal for the purposes, let us say, of count 1, where there were no HVTs or high-value targets or PRD lists or kill lists or what have you. It is not as if criminals have identifying features such as a shifty look or a 5 o'clock shadow or a sack marked swag. In other words, the definition suspected drug pusher or suspected criminal entails the exercise of discretion on the part of the perpetrator implementing the organizational policy. It is a shifting and mutable concept. It is a subjective determination. In our submission, there has to be, at the very least, an objectively discernible characteristic which unites the members of the targeted group such that they can be deemed a civilian population for the purposes of the attack. Leaving the determination of membership of a civilian population to the people who pulled the trigger introduces a degree of random selection, and as cited quite clearly in the Al-Hassan confirmation decision at paragraph 149, the prosecution must prove that the attack was not directed against a limited group of randomly selected persons. This ruling, Your Honours, was the expression of the law as it had stood for many years, ever since the decision authorizing an investigation in the Kenya situation, where at paragraph 81, the pre-trial chamber defined a civilian population as a group sharing, and I quote, distinguishing features, and added as follows, and I quote again, the prosecutor will need to demonstrate to the standard of proof applicable that the attack was directed against the civilian population as a whole and not merely against randomly selected individuals. So let us ask ourselves whether the alleged attack in this case was directed at the population as a whole or at a subjectively defined subgroup of perceived or alleged criminal offenders. The minute the distinguishing features of the civilian population in question are defined through the application of subjective criteria, the targeting process becomes completely random. The targeted civilians are perceived criminals, but perceived to be so by whom? Is it not the case that one man's despicable criminal is another person's righteous saint? In fact, have we not heard from the civil society that many of the victims were not drug pushers or criminals, but innocent members of the local community? To me, and as a matter of logic, it would appear that the targeted population in the Duterte case was selected randomly, even according to the prosecution's own witnesses, who talk about quotas of neutralization that had to be met, and their motives for target selection, which had frequently nothing to do with suspected criminality, but rather personal vendetta, or on one occasion, just because the victim had cheated at cards. With that, Madam President, Your Honours, I conclude the chapeau or contextual requirements of crimes against humanity. And I will now turn to the modes of liability or means of perpetration. Now, I have racked my brain for many a month pondering one question. If Rodrigo Duterte was so shamelessly brazen as to broadcast his murderous intent in public ever since he was the mayor of Davao, why did it take the ICC prosecution almost 4 years to open an investigation after Rodrigo Duterte pulled his country out of the International Criminal Court? After all, why did the ICC prosecution not just save itself all the hassle of its jurisdictional problem, a fundamental issue that still plagues it and remains to be resolved by the appeals chamber? We won't talk about that today, obviously. But why did the prosecution not seek to initiate its official investigation within the 1-year withdrawal period, especially given the fact that Mr. Karim Khan, the victim's representative embedded in the role of chief prosecutor, had received judicial authorization to interview at least one of the criminal cooperating witnesses substantiating the crimes of the Davao mayoral period? Well, for me at any rate, it didn't take too long for the penny to drop. As I mentioned in my opening statement, the prosecution knows that it is not enough simply to assert that Rodrigo Duterte said outrageous things and that deaths occurred, and so, as a result, he must be criminally responsible. There is a requirement for what is called a causal nexus. The prosecution has to show which one of Duterte's statements, orders, or commands were given to a specific individual who then went out and pulled the trigger or communicated the command to someone else who also went out and pulled the trigger, killing one of its 78 identified victims. That would have been the classical way to prove a causal link between stuff that came out of Rodrigo Duterte's mouth and the deaths pertinent to the case. That would have been ordering under Article 25(3)(b. But the prosecution cannot show such a causal link. They've never been able to do that. They show you a lovely pyramid. It's on the screen, with Duterte at the top, the co-perpetrators underneath, the DDS handlers underneath them, and the hitmen perpetrators at the very bottom. To quote Mr. Julian Nichols, how cute. But what the learned prosecutors can't show you is the connecting line between Duterte at the top and the next level down, comprising the so-called co-perpetrators. I hope Ms. Croft will forgive me for vandalizing her screenshot, but there you have it. That is where the apex slips off the pyramid of Giza. The most they can do is allege that they're cooperating witnesses who pulled the trigger and whose credibility is about as worthless as a devalued peso, understood that killing is what Duterte would have wanted, or that they had no choice but to comply because that was what was expected of them by their handlers, or other such similar expressions of a totally subjective sense of obligation. But as they know, not one of the 49 incidents mentioned in the document containing the charges manifests such a causal link between a speech, an order, and one of the charged incidents. I will state it for the record. In fact, I will state it a number of times during my submissions. There is no smoking gun in this case. And that is not for want of a desperate attempt to find one on the part of the prosecution, with all their leading questions when they interviewed their criminal cooperating witnesses. Not one witness relevant to any of the 49 incidents with which Mr. Rodrigo Duterte is charged will testify that he received a direct order from the former president to go out and kill someone. Let us just digest this. All those speeches where the former president made various threats to kill, but not one demonstrable incident set out in the prosecution's document containing the charges, which details an act of murder committed as a result of a direct order given by him. This, in and of itself, should be sufficient to convince any reasonable bystander observing the conduct of these proceedings that Rodrigo Duterte is innocent of these charges leveled at him. It is for this reason, and because of the complete lack of reliable cooperating witnesses, that the prosecution has alleged not one, but a plethora of theories as to the means of perpetration, to link the crimes allegedly committed to the person who is far removed from the incidents of murder and who has been targeted for prosecution. And I say targeted for prosecution. Normally, I would say that such a multiplicity of legal theories speaks to a lack of clarity and prosecutorial uncertainty. Indeed, some of these modes of liability, as pleaded, contradict each other as a matter of logic. Nonetheless, I would like to make the following general observation. As the defense has progressively reviewed the massive databases of evidence disclosed, it has become increasingly apparent that given the absence of direct evidence directly implicating Rodrigo Duterte or even indicating his participation in or control over any one of the 49 incidents alleged in a document containing the charges, the prosecution has resorted to papering over the cracks with human rights reports, press statements, hearsay, and of course, Mr. Duterte's bluster and political hyperbole. And where these documents will not suffice, the prosecution has resorted to the time-worn theory of indirect co-perpetration, Article 25(3)(a), of which the parameters, I would respectfully submit, are still subject to dispute. So I will now turn to this mode of liability, which is the principal mode of liability levelled at Rodrigo Duterte. As we all know, in order to prove criminal liability through indirect co-perpetration, there is a need to show a common plan upon which the suspect and his co-perpetrators, because you need co-perpetrators for indirect co-perpetration, a plan on which they mutually agreed. And that common plan must, without exception, have a criminal element. As I have already stated, the only plan in play was not just totally legitimate in nature, but was, in addition, wildly supported by the Filipino electorate, which ensured that Mayor Rodrigo Duterte's governance of Davao City throughout the years would thereafter put him into the Malacanang. According to the prosecution, the criminality of the common plan expressed itself as follows, and I quote from their documentation: an agreement to neutralize alleged criminals in the Philippines, including those associated with drugs, through violent crimes, including murder. Well, they really covered all options there. The existence of such a criminal plan is, of course, entirely preposterous, and, I should say, totally denied. I would suggest that the prosecution cannot point to any particular point in time where there is direct evidence indicating that even two of their so-called co-perpetrators actually met to agree to such a preposterous scheme. As such, the plan cannot be described as common to anyone. If anything, it's an artificial construct derived from the 10 assertions which are set out in paragraphs 24 to 33, inclusive, of the prosecution's pre-confirmation brief, all of which comprise circumstantial evidence of the lowest quality, pointing to a mutually agreed design which exists in the prosecution's mind and nowhere else. Of course, there is nothing wrong with construing the existence of a common criminal plan from circumstantial data. But the cardinal rule of such a category of evidence is that the incriminating facts derived therefrom must be the only reasonable inference in the circumstances. What we can say with a degree of certainty, which reaches more than a substantial degree of certainty, is that no inference can be drawn from the comments of crime-based perpetrators. And to hammer the point home, I would like to screen you just a selection of excerpts taken from the interviews of a number of the prosecution's criminal cooperating witnesses, or witnesses. Interviewee, at least more or less than 10 buy-bust operations. Where somebody was shot, asked the interviewer, yes, sir. Interviewer 1, okay. And on those 10 occasions, was the shooting justified? Interviewee, yes, sir. Number 2. So, if he shot at us, we would also shoot back. But if he were to stab at us with a knife, then we wouldn't. We wouldn't shoot a person that was holding a knife. And the third one, witnesses who said, the PNP never said kill those people. Another quote, from what I recall of the incidents that I was at, all of them had guns, and they were pointing them at the pusher-buyers, or they were pointing their guns at the pusher-buyers. At the operations I was at, I'm talking about the operations I was at, the reason that they were killed was because they were pointing their guns at us, or they were firing their guns at the pusher-buyers. That's from the prosecution's own witnesses. Now, let us analyze the other circumstances as set out in paragraphs 24 to 33, inclusive, to see whether a meeting of minds between co-perpetrators is indeed the only reasonable inference in the circumstances. The first indication, and that is that in the late 1980s, in other words, 20 years before the charges in this case, Mayor Duterte allegedly instructed civilian confidants and local police to neutralize. And I stress to neutralize and not to kill criminals. That's what's stated in the PCB. And that he provided weapons and funds for this purpose. Now, I would say that there is nothing untoward in providing policemen or civil volunteers with weapons to carry out their lawful duties. That's what happens in my country. The prosecution has not shown us how arming civilian volunteers is actually illegal. And the burden of proof rests on it. After all, one does not fight crime with kind words and gentle admonishments. The fact that these conscripted civilians understood the words to neutralize to mean to murder is not something for which Rodrigo Duterte must be held responsible. Trust me, had any one of the unreliable, insider, criminal cooperating witnesses substantiating the assertions made in paragraph 24 of the pre-confirmation brief said that Rodrigo Duterte gave a direct order to murder one of the 78 victims, the prosecution's lawyers would have written it into their charges, point blank. But they did not. And furthermore, any false allegation made by cooperating criminal witnesses made years before the charged incidents and without the time frame of the case does not constitute pattern or similar fact evidence indicating a predisposition to murder criminals. Accordingly, the allegations concerning the activities of the so-called Davao Death Squad, formerly the so-called Lambada Boys, are irrelevant both to proving a criminal plan and that such a plan, more importantly, was common to any of the so-called co-perpetrators mentioned in the document containing the charges and released a few days before the confirmation hearing in a lesser redacted version of the PCB. Now, thinking like a prosecutor, I would say that the reason why the prosecution has fixated